that sort of view right now?
I'm not one of the jurors. I'm not one of the alternates, and there's a lot that goes on in those dynamics, and who knows what's going to happen.
All right, this is from Steve Carter in Tallapoosa, and he says it seems like Doug Chalmers, the attorney, may be too polished. Could that backfire with the judge?
Absolutely not. Mr. Chalmers is making a very strong argument, weaving the facts and the law into his argument that these charges should be dismissed. I think the judge appreciates very sober presentation. The drama and the theatrics are more for the jury. This judge wants to know what the facts have been in the testimony and wants to know how the law applies, and I'm sure he appreciates the presentation that the attorney has made.
With Jay Strongwater right now, the defense attorney, here's another question. This is from David, and help me with this one, and I'm not sure this is going to make a lot of sense. Maybe you can make sense of it, being an attorney and all. Here we go. That a judge interjects during motion for direct verdict hearing.
Yes.
Can you explain that?
Well, there's a presentation made by the attorneys. They're raising or summarizing the facts as they recall it. They're citing law as they have read it, and occasionally the judge may not remember the testimony precisely as it's being summarized by the attorneys, and may have a particular interest, as you've seen with the perjury charges, and he wants an immediate answer. That would be an academic answer. The other answer is that he's sitting there quietly for over an hour trying to be quiet, and occasionally he wants to get involved and have some exchange so that he can focus on what he needs to decide now that he's back in his chambers.
From Israel Bucksbaum, for you, do all judges have a sense of humor as good as Judge Adams?
No.
In a word, no.
That's correct.
All right, so here we are. It is coming up on 10:35. Judge Adams has taken the second break of the morning, kind of a short break. We began at 9 o'clock today with the jury out of the room. The jury's still not in the room right now.
That's correct. They've heard nothing that's gone on this morning, and they didn't hear anything late afternoon after the state said they rested. These are all legal arguments made to the judge, who will decide what counts, if any, go to the jury.
At what point will the jury come back in, do you think?
After the judge comes on the bench, he'll make a decision on the directed verdict motions by Sneiderman. He will then ask the defense if they have any evidence to present, and then he'll bring the jury in, and the defense will proceed with calling witnesses, or if they have nothing further to say, they'll announce in front of the jury that they rest. The judge will then dismiss the jury, and the attorneys will then proceed to have a charge conference about what law will be submitted to instructed to the jury about how they should evaluate the facts.
What is the judge weighing right now?
He's looking to see whether the facts are sufficient to give it to the jury to make a decision on guilt or not guilty. The judge has somewhat of a safety valve. He can let the jury decide any of the counts, and he can then undo a conviction after they've decided. So he can play it safe, he can give it to the jury, and then he can vacate some of the convictions if he wants to go that way.
There are those questions from the defense, and defense is your specialty, about playing the hand that you already have with Andrea Sneiderman. This is the great poker game, it would seem, at least from a legal standpoint, as I've heard some attorneys speak over the last 12 hours. How much evidence, if you are the defense right now, do you submit before the jury? And if you do, it's got to be a laser beam. It's got to be very, very tight in terms of the information so the jury understands it. Or do you just play the hand that you have been dealt at this point and say, look, the state has proved nothing. It remains ambiguous. They haven't proved anything about infidelity. They haven't really proved a timeline at this point. They haven't proved the fact that she was less than sincere with Dunwoody's detectives. On and on it goes, and most of those who have been on the stand, whether it is Shana or Melanie White, the realtor from Dunwoody, a lot of that has been hearsay evidence as well.
It sounds like you've appreciated the defense to date, and the question...
I'm merely throwing that out. I think my role is to try and sort of throw out these kinds of statements on both sides, and I've tried to do that over the course of the last couple of weeks. Do you like how I'm spinning that?
Yes, I do.
Okay.
I think what they might be doing is going back to Tom Clegg's opening statement, looking at the points that he said that the defense would prove and going through the checklist and say, have we proven it? Have we shown enough evidence, if not to absolutely get testimony that absolutely negates the state's charges, but does it give us enough facts so that we can argue it? And is that sufficient to rest, or do we need to bring up a witness to either pinpoint a particular issue that is outstanding, or do you take a sweeping defense by starting to attack both the lay witnesses and the professional witnesses that testified in the case?
So now we begin to speculate about who will make the closing arguments. Kelly Stevens Hill, for the district attorney, did a terrific job on the opening statement. Tom Clegg did the opening statement for the defense. Will both of those attorneys not only open but will also close? Or might we see J. Tom Morgan? Might we see Kelly Cross? Could Robert James step back up?
Those, again, this is a team defense and a team prosecution. There's been a division of labor throughout the 6 days of testimony. That's probably already pre-assigned. You have Tom Clegg that has developed some rapport with the jury. He's done most of the cross-examination, and he would understand the dynamics of the 12. You have J. Tom, who's the former district attorney that's picked jurors for years, and he would also have a great rapport. On the state side, you have the elected district attorney. This is a very notorious case, and he may want to get his 2 cents in front of the electorate that votes for him.
You think there are political ramifications? I've asked this of many of the attorneys that we have had here. You bring up politics, so I'm going to kind of follow up with a question here. Do you think it does have political ramifications if she does indeed walk? Does it matter in DeKalb County, which is 700,000 people? Does it stick to his ribs, so to speak?
I don't think this is the type of case that would. It's you could look at other counties where there's been notorious murder cases where people have not been acquitted. Those district attorneys have been reelected. There's some, in the legal community, there's some feelings, some hard feelings about it, some overzealous prosecution. But I think in the general electorate, they look to see whether the county's functioning well, and they don't look at a particular case.
As you look at what we have seen over the course of the last few weeks, should the state have dropped all charges against her?
You're asking a lifelong criminal defense attorney about whether they should have.
Maybe this
you would have liked to have had Andrea go about her life. I mean, she has suffered. Her family has suffered. You saw her mother on the stand. Her children are Sneidermans, and in the community at large, she is one day going. The kids will always be Sneidermans, and some adult is always going to tell their children, "Oh, you know who those kids are."
Well, our time right now is 10:40. We are in the midst of a break. I'm Jeff Hullinger along with Jay Strongwater. If you have some questions for Jay, who is very candid in his responses, you can contact me through Twitter. That's at 11Hullinger, Hullinger, or you can email me at J, and it is the initial J, Hullinger, Hullinger at 11alive.com. We are outside the DeKalb County Courthouse. We have been wading our way through trucks, buses, fire engines, and police cars for the past 3 weeks, and we appreciate your patience, as oftentimes it has gotten a little noisy on this thoroughfare behind me, but we will continue to have coverage of Andrea Sneiderman's trial on our various platforms, not only on the digital channel 11.2. You may be watching on 11alive.com, where we are streaming it as well. We will have coverage coming your way at 6 o'clock, then at 7 o'clock. We have dedicated the entire Last Word broadcast with Brenda Wood and Judge Glenda Hatchett. I will be here with Marcia Shine, who will be joining me, who is the president of the Georgia Association of Trial Attorneys. She will be with us at 7 o'clock. Then we will have coverage coming your way on the Rundown on my ATL TV at 10 o'clock, and then on 11 Alive at 11 o'clock. So we have you covered on the Sneiderman trial night and day, to borrow a line from Cole Porter from many years ago. So right now we're taking a look at both sides are waiting on the judge, and the judge is rendering decision. Would you guess now?
He is, and you you have commented throughout the week that the judge is very prompt. When he says 6 minutes, he means 6 minutes. He's back in chambers, and he's probably looking at the books. I don't think they have testimony prepared, but he's looking at his notes, and he's reflecting back on the arguments as well as the testimony. And judging from the amount of time he's taking, he's going to come out with an opinion, and I'm sure the defense at this point is reasonably optimistic that some counts will be tossed.
You know, it's kind of gone back and forth over the last couple of weeks about whether Andrea should have taken the plea deal or not. The offer that we all understand and the one that we all have been told about from our sources, hidden and not hidden, is a year in jail, of which he probably would not have served, that she is gambling by going to trial, and with these 13 felonies that she is facing, if she were convicted of a couple of them, Judge Adams would have a pretty strong sentence toward her. Do you have any view of that as you have followed the travails of this trial?
Well, sometimes people are not guilty of the charges, and in her heart of hearts, she feels that she has not done anything wrong. It's the hard cases are the ones where people are not guilty. The easy cases are when someone's caught red-handed, and you can explain the spread between what you're risking at trial versus what the offer is. In this case, Andrea Sneiderman clearly believes that she has done nothing wrong, and to stand in front of a judge and say, "I've done something wrong," is just contrary to her firmly held beliefs.
We're looking at J. Tom Morgan, who is standing about. We have not seen a lot from him. You know, he may be behind the scenes, his involvement of something that we don't see, but we haven't seen a lot from him. We have, at least publicly, we saw him on the cross-examination of Shana Citron, and that has been about it. And now the conventional wisdom seems to hold that Tom Clegg will be doing the closing statements as well.
That's true, and they've worked together when they were in the district attorney's office. And it's a question of who has the best rapport, grasp of the facts, and is most comfortable doing this. If you remember, I think Tom Clegg gave a 45-minute or longer opening statement without notes. He knows these facts backwards and forwards. Going back to one of your earlier questions about why Andrea Sneiderman may not have taken the plea, is that there are some collateral, there are issues that are outstanding aside from the criminal prosecution. There's lawsuits for both from the estate. There's questions about child custody, and those may have factored into her decision that she needs to fight these charges so that she can address those civil cases at a later date.
There's a question from John Zuccarini. John says, it seems as though the prosecution is asking the jury in this case to make a decision based completely on connecting the dots. Does that appear to be the case?
Yes.
In your estimation?
Yes, they're using the frequency of the contacts, the cell site data to show that Hemi and Andrea Sneiderman were together. That's a fact that is objective. Then they want to go from there to say, well, if someone spoke to another person that many times, something must be afoul.
This is from Morgan, and he or she says, it looks like the state case is circumstantial. Ask the attorney to comment on individuals to be convicted on circumstantial evidence. How often does that occur?
Well, the judge will instruct the jury that circumstantial evidence is just as strong as direct evidence. The jury is going to have to see whether they agree with the state's connecting of the dots, or whether they're going to say this is suspicious, but it's not to the level of proof beyond a reasonable doubt. I like to have first-time jurors. I think they take that beyond a reasonable doubt standard much more seriously than a second or third-time juror, because they've already heard the words guilty, and they have less of a hesitation to say it again.
This is from Leslie. First, I want to compliment you guys on the coverage of the trial. Secondly, in my opinion, this trial has been a waste of taxpayer dollars. I believe she did have some type of flirtation with her boss. It was short-lived, but I do not feel that she had anything to do with the murder of her husband. This is a tragic case of fatal attraction.
perhaps that would be woven into the defense closing argument later this week.
All right, it is about 14 minutes before 11 o'clock. The judge generally has been giving a lunch break around 12 noon, and then it goes for 90 minutes, and then we start anew at 1:30. Here is Judge Gregory A. Adams, who runs his courtroom like a train. It is right on time.
All right, Kelly, we're back on the record. I'm sure Ms. Kaufman, we're back on the record. As far as defense motion for the directed verdict of acquittal as to counts 1 through 13, I'm going to deny the motion at this point in time, and the case will go forward to the jury. Is the defense ready to proceed?
Ready, Your Honor.
All right. Let me do this. Mr. Snyder, would you stand? Let me advise you of your rights to testify. Ma'am, would you raise your right hand, please? You solemnly swear or affirm that the evidence you're going to provide the truth, self you God?
Yes.
You may lower your hand. Would you state your full name for the record, please?
Andrea Sneiderman.
Mrs. Sneiderman, the state of Georgia has indicted you in case number 13-CR-2413, State of Georgia versus Andrea Sneiderman, which is a 13-count indictment. You are still presumed innocent unless until proven guilty in a court of law. The state has rested this case. It is your opportunity to testify on your own behalf if you wish. It's completely your decision. You can consult with all 4 of your lawyers or any additional lawyers you need, but it's ultimately your decision on whether or not you want to exercise your right to testify during the course of your trial. Have you had an opportunity to make a decision on whether or not you want to testify during the course of this trial?
I have not yet decided.
All right. Do you need any additional time to talk to your lawyers?
I will need some additional time. Yes.
All right. How much time do you need, ma'am?
Maybe a day or 2.
Well, I'm not going to be able to give you a day. You have 4 lawyers. I'll rephrase that. It is currently a.m. right now. I will give you until 1:30 as far as that will be the session that we will reconvene. All right?
Your Honor, may I object to that?
Sure.
She obviously has to state on the record prior to the close of the defense case her intention as to whether she herself has decided to testify or not. We have absolutely no objection to her doing that.
Oh, so you let me.
Anticipate.
You want her to wait till the end?
Yes.
Oh, she can do that. I have no problem with that. But when you said a day, I interpret it to mean we can't do anything else for another day.
No, by no means. We fully intend to go forward with other witnesses prior to the conclusion of our case.
Oh, sure. I have no
We will
problem
make
with
that announcement.
Well, I have no problem with that, Mr. Collect, because my next question was going to be to either you or Mr. Morgan, Mr. Petrie, or Mr. Chalmers. Is there any other evidence you could put on while she's making that decision?
Oh, yes, absolutely.
Oh, in that case, so that's not a problem. So, right, I have no problem, Mr. Clegg. She doesn't have to give me a response at 1:30. That's not a problem. If she wants to wait until the conclusion of the trial, that is not a problem either. So that's not a problem. So, without knowing how many other witnesses you may be calling, would, Mr. Clegg, since you're standing, would you take the responsibility to let me know when you are at the end of your case so I can re-advise of her rights?
Yes, sir,
All
absolutely.
right. And I'm looking at you, Mr. Clegg, but Ms. Sneiderman, you can take as much time as you need while you're thinking about that. If we are on trial for another 30 days, it's okay.
Thank you.
And then at 29 days and a half, I'm going to come back and ask you that same question
understand.
if you want to exercise that opportunity. Also, Mr. Clegg, if she can think about it also over the weekend, if we go into the weekend or even next month, it's okay. So I'm not rushing you and making a decision. You take as much time as you need. But I just need the lawyers just to give me some idea when you're close to the end. Just so it helped me just timing with the
Yes,
jury.
sir.
Okay.
No problem with that
Okay,
whatsoever, Your
so
Honor.
you don't have to respond by 1:30. You don't have this. What's today? Tuesday. You don't have to respond this week.
Okay.
Okay.
Well,
So
we will be responding this week.
no, you don't. But you don't have to.
Yes,
Because I want to make sure I'm not rushing anybody. All right. So okay.
Okay, thank you.
Thank you, Mr. Morgan. Since you were standing, I'm assuming in light of that, which is fine. She doesn't have to make a decision. Take as much time as she needs. Are you prepared to call a witness if you wish?
Yes, sir.
All right. All right. Let's do it that way. Wonderful. Deputy Garrett, if you would you invite the jury in, please? Thank you, sir. And Mr. Morgan, or Mr. Petrie, or Mr. Clegg, Mr. Chalmers, we follow the same procedure as far as if you could just have your witnesses in queue so that when they are ready for it, and once one witness is finished and they've done the cross-examination, to have the next person call.
Okay.
You know.
Your Honor, my witness decided to call. I want to go ahead and get her.
You can. Come on in, ladies and gentlemen, make yourself comfortable. Come on in, ladies and gentlemen, make yourself comfortable. Let me thank you in advance for your patience. Come on in, ladies and gentlemen, make yourself comfortable. Come on in, ladies and gentlemen, make yourself comfortable. Come on in, ladies and gentlemen, make yourself comfortable. You may be seated in the seat. Come on in, ladies and gentlemen, make yourself comfortable. Come on in, ladies and gentlemen, make yourself comfortable. You may be seated in the seat as long as everybody has a seat. Wonderful, wonderful. Lawyers and parties, you may be seated. Ladies and gentlemen, first of all, let me thank you again for your patience. Just have some matters to take up outside of your presence. Don't draw any inferences from that one way or the other. At this point in time, as you heard yesterday, the state of Georgia has rested its presentation. Now we can turn to the defense. The defense does not have to put up any evidence at all if they don't want to. But if they want to call witnesses, they may. At this point in time, Mr. Morgan, you may call your first witness.
Thank you. Defense calls Jane Newman to the stand, Judge.
Jane Newman, come on up, young lady. You'll be sworn in by Deputy Garrett.
All right, raise your right hand. Do you solemnly swear or affirm that the testimony you shall give this court should be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. You may be seated. Please state and spell your name for the record.
Jane Newman, Janewman.
Ms. Newman, how are you employed, ma'am?
I am the Executive Director of Dunwoody Prep,
And how long have you been in that position?
26 years.
And where is Dunwoody Prep located, please?
It's in the heart of Dunwoody, the intersection of Chamblee, Dunwoody, and Mount Vernon.
Okay, and what type of business is Dunwoody Prep?
It's an independent private preschool. It's an accredited independent private preschool,
And what age children are in the preschool?
from infants through young 5.
And approximately how many children do you have there at any given time?
169.
And is it a round-the-year facility?
Yes,
So every day, there are children at Dunwoody Prep?
yes.
Do you know Rusty and Andrea Sneiderman? Did you know them?
Yes.
Okay. And how did you know them?
They were a family in our school.
And do you remember the child's name that was in your school?
They had 2 children, but the child at the time was Ian Sneiderman.
Okay. Did you have Ian's older sister, Sophia, as well?
Yes.
Did you know Rusty and Andrea outside the business relationship of the school?
No.
Did y'all attend the same church or synagogue?
No.
Did you visit in each other's homes?
No.
So your relationship was a professional relationship?
Yes.
Would that be fair? Okay. Calling your attention back to November 2010, November 18th. Were you at Dunwoody Prep that day?
Yes.
Okay. And what time do you usually get to the business?
8 o'clock.
Okay. And were you at the business at 8 o'clock that day?
Yes.
And if you would, please tell the ladies and gentlemen of the jury what happened that morning at Dunwoody Prep. What you observed. Now let me explain. Not what other people told you happened, but what you were able to observe.
Well, actually, I was in an accreditation meeting with the Georgia Accrediting Commission looking at my paperwork at that time. I was inside the school.
Did you, for any reason, ever go outside the school to the parking lot?
No.
Okay. Are there security cameras at Dunwoody Prep?
Yes.
Are those security cameras inside and outside the facility?
Yes.
So you have cameras inside the building as well?
Yes.
Okay. You never went out in the parking lot that day?
No, I was taking care of things inside of the school.
Did you see Andrea Sneiderman that morning?
Yes.
And where did you see her?
She was in my office.
Okay. Did you see Detective Portolino that morning?
Yes.
Okay. And where did you see him?
In my office.
Okay. Your Honor, by stipulation at this time, I'll ask that defendant's exhibit number 30 be admitted.
Any objection?
No, Your Honor.
All right, D30 is admitted without objection. You may publish it to the jury if you wish.
I'm providing the prosecution with a copy as well as that.
You may.
May I approach the witness?
You may.
Ms. Newman, what is the phone number for Dunwoody Prep, please?
770-396-2973.
And did you receive a phone call that morning from Rusty Sneiderman's father?
Yes.
And where were you?
I was in one of the offices.
Did that phone call go through a receptionist, or did it go straight to your office?
No, I answered the phone.
And is this a landline or a cell phone?
Landline.
And that number is 770-396-2973.
Correct.
I'm going to publish this business.
You may, yes, sir.
2:30.
That's an E30, yes, sir. Without objection, you may publish it.
Now, if prior testimony has identified the number 216-464-4260 as that belonging to Mr. Sneiderman, what time did you receive that call? Can you tell?
I couldn't tell you exactly.
Can you look at,
Oh.
would that help refresh your memory?
Well, it looks like, it says 9:40.
Okay. Would that be about the approximate time that you recall you received it?
That could be, yes.
Had you talked to Mr. Sneiderman prior to that time?
No,
At that time, were you aware of what had happened to Rusty Sneiderman, even though you did not observe it?
yes,
Okay. And do you recall the phone call with Mr. Sneiderman?
yes.
Why do you recall that phone call?
It was one of the worst moments of my life. I had to tell a father that his son was shot.
What did Mr. Sneiderman say when he called you? What were his
He
first
said,
words?
"My name is Donald Sneiderman. I'm Rusty Sneiderman's father. What happened to my son?" Just like that.
Did he say that his daughter-in-law had called him? And
No. What happened to my son?
And what were your next words, ma'am?
There was an accident.
And what did he say after that?
What type of accident?
He didn't say he heard she'd been shot, right?
What type of accident?
Okay. And what did you say next, ma'am?
He was shot.
And what did Mr. Sneiderman say after?
He was shot, just like that. So I've had to live with that all those years.
Was there any question in your mind, not in Mr. Sneiderman's mind, in your mind, that you were the first person who told him?
Objection, Your Honor.
I'm going to sustain that objection. You want to rephrase that question?
What was the tone of voice of Mr. Sneiderman when you told him he'd been shot?
He was shot, just like that.
What happened next?
Then he said something like, "In your school?" And I said, "No, in the parking lot outside of the school." And then he said, "How is he?" or something like that. And I said, "I don't know. I'm inside of the school." So after that, it was kind of vague. I think he was talking to his wife, "Should we come?" that type of thing. And I don't remember anymore.
Do you have a clear recollection of that discussion?
After he started talking to his wife, I don't know I couldn't give them any more information. They wanted to know how he was.
But he asked you, has he been shot?
No.
All right. What was his word?
What happened to my son? There was an accident. What type of accident?
Your Honor, I object again. This has been asked and answered.
Oh, sorry.
All right, right now, I'm going to over the objection.
Go ahead.
Go ahead.
Oh, I'm sorry. And that's when I had to say he was shot. And then he said, "He was shot," just like that.
Did you tell any of your staff about your discussion with Mr. Snyder?
Yeah, I turned around after this whole thing, and I looked at one of my assistants, and I said, "I just had to tell a father that his son was shot." You don't forget that.
Now, back to Defendant's Exhibit 30 on the next highlighted portion of that exhibit, there appears to be a phone call from Dunwoody Prep back to Mr. Sneiderman.
He possibly could have left his phone number. I don't remember the rest of that because he probably wanted to know more information.
I'm getting at what
Oh.
I'm getting at. Did you make that phone call?
No, I did not. I did not. I never talked to him again.
But you had one phone conversation, right? And again, Mrs. Newman, the phone call was at originating at 9:40, correct? I want to publish what's been previously introduced by the prosecution as State's Exhibit 92.
You may.
Mrs. Newman, this has previously been identified as a time of a phone call from Andrea Sneiderman to Don Sneiderman. Can you see that? Mm-hmm. And what time is that, ma'am?
I can't see that. 9,
Is there a monitor in front of you?
oh, 9:36.
Ms. Newman, after this phone conversation, were you interviewed by a representative from the district attorney's office?
He was in the office with there were 3 of us in the office, so he was, he interviewed all of us.
And did you see that person in the courthouse today?
Yes.
Do you recall his name?
Cordellino, Detective Cordellino.
Specifically, though, by a representative from the DA's office. Do you remember that?
Oh, I don't remember that.
Was the name Mark Potter, remember?
I do remember, but I don't remember when he came to interview.
Without giving a specific as when he came, did he come prior to your testimony in this courtroom in the unit trial?
Your Honor, I object. I believe her testimony was she doesn't recall when.
I'm going to sustain that objection. You want to rephrase that question?
All right, I'm going to give you a timeline.
Okay,
The incident happened on November the 10th.
right.
On February 2012, you testified in this courtroom, correct?
Right.
Do you recall whether or not you talked with Mr. Potter before or after your testimony?
I've talked to him a few times.
Okay.
He would just show up every now and then.
All right, then let me ask you, do you recall talking to him before your testimony in this courtroom?
And I object, Your Honor.
I really,
Hold on 1 second. What's the objection?
That question has been asked, and her answer was he showed up a few times. She doesn't recall when.
I'm going to overrule the objection. If you can answer the question, you may.
Do you recall Mr. Potter, who you saw out in the court,
right, right.
coming to your establishment prior to your testimony in this trial, or in Mr. Newman's trial?
Yes,
Did you tell him exactly what you told this jury?
I'm sure I did.
Okay. In Mr. Newman's trial, were you ever asked about your phone conversation with Don Sneiderman?
Objection, relevant.
Why is this relevant, Mr. Moore?
Shows her motive for testifying.
Sure.
And
I'm
it
sorry,
shows-
hold on. Shows her motive for testifying where?
And that the district attorney's office...
Wait a minute. Hold on now. Talk to me for a minute. It shows her motive for testifying where? That's what I'm trying to understand.
I am-
Shows her motive for testifying where?
Here, today.
Her motive for testifying
Yes, it
today?
will. I can link it up.
I'm going to sustain that objection.
Okay. After you testified,
When you say after, are you referring to a previous testimony? Okay, go ahead.
before your honor, did
Go
you
ahead.
testify in Mr. Newman's trial?
Yes,
Okay. During the course of your testimony, did your conversation with Mr. Sneiderman that morning ever come up?
no,
Okay. Prior to this case, have you and I ever met?
have we ever met?
Yeah, personally.
Personally.
Or yesterday?
I don't think we've ever met.
Okay.
Okay,
Did you contact him?
yes.
Okay. And when did you contact him?
It was sometime during the Christmas holidays.
Of 2012.
Yes, 2012.
And what was your purpose of contacting him?
I read it.
Hold on. Mr. Morgan, first of all, let me hear the objection out completely.
Relevance, Judge. What her,
You got a lawyer's approach for a minute? All right. I'm going to sustain that objection. Let's move on.
Mrs. Newman, was this the first time you ever given the opportunity to testify under oath about your conversation with Mr. Sneiderman that morning?
Yes.
No further questions.
Any cross?
yes, Your Honor, just briefly.
Ask as many questions as you wish.
Thank you. Good morning, Ms. Newman.
Good morning.
I have just a few questions for you.
Okay.
Mr. Morgan asked you if, prior to your testimony here today, if you had ever met him. You remember that question?
Yes.
Okay. Now, Mr. Morgan's children, in fact, his daughter, went to your daycare center.
I know. I don't think I ever met him, but I met his wife.
So, answer my question and then
Yes.
you can explain it.
That's what I was trying to remember if I'd ever... I don't remember meeting him.
But his daughter went to your school?
It was a long time ago,
She was a student at your school?
about 25 years ago.
And you remember specifically meeting his wife, but not his, not
Yeah, I didn't
him.
even know who he... I didn't know till later. I remembered later seeing his name, that he was a district attorney, and I said, oh, his daughter went to our school.
So you were able to make the connection without meeting him?
Right. So I didn't know how to answer exactly that question.
Okay. Now, you've testified also on direct that you received a phone call from Mr. Don Sneiderman,
Yes.
correct? That phone call was made at 9:40 a.m.,
Okay?
according to what your testimony was.
Okay.
Is that correct?
Yes.
I did not hear that last.
I'm saying, if you...
No, I heard the question from Ms. Hill, I did not hear.
Okay. Ms.
I'll
Hill.
just ask it to be repeated.
I don't mind. I mean, Ms. Hill, if you could, like I do witnesses, talk loud enough so that everyone can hear you.
Yes, Judge. I'm sorry.
No
Use the
problem.
microphone. When you spoke to Mr. Sneiderman, he asked you what happened. Is that correct?
Right.
You need to say yes or no for the record.
Yes.
And you were able to confirm for him the fact that his son had been shot, weren't you?
I said he had been shot.
And that was information that you gave Mr. Sneiderman when he called you, correct?
Right.
And he wanted to know the condition of his son, didn't he?
Yes.
He asked you, how is he? Didn't he?
He did.
And you would agree, Ms. Newman,
Yes.
that this is a conversation that you won't forget.
Right.
Is that correct?
Right.
Because a man, Mr. Sneiderman, had called you
Exactly.
and asked you what happened to his son.
Yes.
Is that correct?
Yes.
And when Mr. Sneiderman called and asked you what happened to his son, you had to tell him that his son had been shot.
Yes.
Correct?
Yes.
Now, you don't know who he spoke to before he spoke to you, do you?
I have no idea.
But you remember the conversation you had with him.
Yes.
Because it was traumatic for you, wasn't it?
Exactly.
It was something that you will never forget because you had to tell a man that his son was shot.
Exactly.
correct? Would you agree with me, Ms. Newman, that a man receiving that news that his son would be shot will never forget that conversation either?
I'm going to sustain that objection. You want to rephrase that question,
Yes.
Counselor? You may.
Would you agree with me, Ms. Newman, that the news of a person being shot, the news you had to deliver,
Yes,
that's something that's etched in your mind forever, correct?
yes.
Thank you.
Mr. Morgan, any redirect? Lawyers may, Ms. Newman, let me just make sure, spell your last name for the record, please.
Newman.
But you are not related by blood or marriage
No.
to Mr. Hemi Newman, who spells his Neumann, is that correct?
Correct.
All right, different spelling.
Yes.
All right. You may come on down, you're free to go. Call your next witness, Mr. Clegg, Mr. Morgan.
Defense calls Detective Cordelino, Sergeant Cordelino.
You may.
He's out in the hall, sir.
Yes, sir, thank you, Mr. Morgan.
Start around, raise your right hand. You solemnly swear affirm that the testimony you shall give this court shall be the truth, the whole truth, and nothing but the truth, so help you God. May you be seated. Please state and spell your name for the record.
Gary Cordelino, Cortellino.
Sergeant Cordelino, how are you employed, sir?
Sir,
How are you employed?
I'm with the City Dunwoody Police Department, Detective Sergeant.
Your sergeant?
Yes, sir.
Okay. If you would, please give the jury a brief history of your law enforcement career.
Well, I started with Dunwoody in March of 2009. I retired from DeKalb Police in January 2009 at the rank of Detective Lieutenant with 30 years service.
You were 30 years with the DeKalb Police Department?
Yes, sir.
And what are some of the various positions you had with the DeKalb Police Department?
The majority of my career was with the Criminal Investigations Division. Every time I was promoted, I was sent back to uniform, which was the policy. But then I was fortunate enough to get back into CID at the next rank. So I started off as a patrol officer. Then I went into detectives, promoted to sergeant, went back to uniform, back to detectives, made lieutenant, went back to uniform, and then back to detectives.
So the jury understands is that sergeant is over detective typically.
Yes, in rank structure, yes.
Okay. And then below the detective is the patrol officer.
Yes,
Okay. And what is the rank above sergeant typically?
lieutenant.
Okay. And is that the same way in the Dunwoody Police Department?
Yes, sir.
Your duties and responsibilities at the Dunwoody Police Department, what are they, Sergeant Cordelino?
I supervise a group of detectives in their task investigating criminal offenses.
Okay. Do these criminal offenses include misdemeanors and felonies or just felonies?
No misdemeanor, felonies.
No misdemeanors?
Misdemeanors and felonies.
Okay. And going back to November the 18th, 2010, were you on duty that day?
Yes, sir.
The misdemeanors and felonies, let me go back. They include all types of crimes, including homicides.
Well, I like to say hubcaps to homicides. That's the way we say it.
I'm sorry, you said what now?
Hubcaps to homicides.
Hubcaps to
To
I
homicides.
just want to make sure I heard you. Go ahead.
That's just a cliche, Judge.
All right, go ahead.
So y'all in charge of everything. You don't have like a homicide division,
No,
a sex
no.
crimes division, a child abuse division?
That's correct. We handle anything that comes in.
Okay. Prior to November 18, 2010, how many homicides had your unit been in charge of investigating, if you can recall?
In November 2010, we had a double homicide. In July of 2010, an elderly couple was murdered. And that was our first homicide.
Now, it's your first homicide, and has that one been solved to the best of your ability?
No, sir.
On November 18th, if you would please tell the ladies and gentlemen of the jury, did you receive a call to Dunwoody Prep that day?
Well, the police department received a call. I was called on the telephone. I had an appointment in the morning, and I was told through a telephone conversation that there was a shooting at the, well, initially we got it at the bank, one of the banks behind the prep center. But when I arrived, it was at the prep center. I arrived about 20 minutes after that.
What did you observe when you got to the crime scene?
The victim, Rusty Sneiderman, was already transported to the hospital, so what was remaining was his car. Some of the officers that had already arrived there started circling the shell casings that were left at the scene. There was,
So the jury can understand, when you say circling, what does that mean?
the officers spray paint around some shell casings left from the bullets that were shot at the scene. And then we had the yellow tape barrier set up that you see at a crime scene.
And that tape says what on it?
I believe police crime scene do not cross.
That had already been set up by the time you got there?
Yes, sir.
Do you recognize Andrea Sneiderman, the defendant in this
Yes, I
case?
do.
Was she there when you got there?
No, sir.
How long were you there before Mrs. Sneiderman got there?
I'd say maybe 20 minutes.
And what did you do during that?
During the 20 minutes?
Yes, sir.
Well, I was supervising the crime scene. I was dispatching officers. I dispatched one detective to the hospital, to Atlanta Medical Center. I had one detective or two detectives available to start canvassing the shopping center. This was a very open, wide open crime scene. Typically, you like to have a covert, but this was out in the open, so we had a lot of people starting to gather. We had officers and detectives just going through the crowd to see who actually witnessed anything. And then, of course, I had the crime scene itself, the car. I had two crime scene technicians available, and they were looking at the car to look for any type of evidence.
Where were you, if you recall, when Mrs. Sneiderman got to Dunwoody Prep?
I was supervising the crime scene, so I was inside the tape looking at the car from a distance. So I wasn't actually at the car, but close enough to it. I was unexpectedly surprised to see that the wife was there. I did not expect to have someone there, so I didn't really know that she was coming, so I wasn't prepared for that. I wasn't prepared, certainly not to interview her. But one of the officers, and I can't remember who, I think it was Lieutenant Fladrick possibly, but he came and told me that the victim was now at the daycare center. I was on one side of the daycare. Apparently she came in maybe possibly, I guess you would regard that as the front side, the front door. So I went around the back side and came out the front door.
So you were there when she was approaching the daycare center?
I didn't see her. I had heard she had arrived at the daycare. She had approached others before I approached her, other officers.
Okay. But you approached her there?
Yes, sir.
Okay. And I believe it's State's Exhibit 60, which has already been played to the jury. I would ask it be published at the video. Just got
I'm sorry, what number? 60? Should be with Ms. Carpenter. Yes, you may publish it, yes, sir.
We can play it through our system.
You can.
Without reinserting the disc.
No, you
Play the same
can.
thing.
If it's states 60 and it'd be, you want to mark it as one of yours too, or just stay 60?
We can just use it as the State's.
Okay.
Don't mind marking.
You may cue it up, sir, at your leisure.
Can you see that?
Oh, yes, I can hear. Okay.
Okay. Do you recognize where you would be at this moment?
If you stop it, you see this brick wall on the left?
Yes, sir.
That brick wall is surrounding a playground for children. So you see one side here.
You can touch the screen.
Oh, I can, it will come up? Well, I won't do that. I see it, okay.
You see it?
Yes,
You see
sir.
it? Yeah, you can
Just
touch
go
it.
around this way and come around. It's like a square horseshoe. The crime scene is right there where my ex is.
Let me continue, please, Mr. Williams.
And so I know, what am I looking for?
Stop.
Okay.
Do you recognize Ms. Sneiderman?
No.
Okay. Where's the crime scene? Can you?
Right where the X is, on the other side of the wall. Imagine this cement brick wall. It's a brick wall about 10 feet high. It goes around into a square shape horseshoe, so it's three-sided.
You see an officer and a woman on the left side of the screen. Can you identify the officer and the woman?
I believe that's Detective Maldonado.
And the female that he's with?
I assume that's Ms. Sneiderman.
Okay. Please continue, Mr. Williams.
Just about this point, I guess at this point, I don't know, but I'm told that the wife had just arrived, so I had gone around.
Say, as to what he's been told.
Yeah, I'm going to respond to that. I sustain that objection. Just at this point in time, Mr. Morgan didn't ask your question, so
Okay.
wait till he
Yes,
asks your
sir.
question.
Do you know where you are at this point in time?
I believe I'm still at the crime scene.
Please continue. Did you tell who escorted her in, Sergeant?
I can't be certain. I think it might be Lieutenant Hegwood, but I'm not certain.
Did you meet her outside the facility or inside the facility?
I believe I was just at the doorway, at the door, going outside from the inside.
And where did you take her from that moment on?
As you enter the door, I'd say about 20 feet, there is a glass-enclosed office. I assume it's that way to look at the classrooms, which are all basically glass-enclosed also. It was an office space right there.
Did you speak with Mrs. Sneiderman during that time?
I didn't interview her.
No, that's not. Did you talk with her?
I did speak with her.
Were other people in the room when you spoke with her?
Yes.
Do you recall asking her who would have done something to Rusty?
I don't believe I said that.
Do you recall telling her that her husband had been shot?
No,
I'm
sir.
not going to object to leading the witness.
I will sustain that objection. Let's ask non-leading questions. Those are questions that do not suggest the answer.
Do you recall telling her anything about what had happened to her husband?
The best I can recollect from that morning, I did not tell her husband was shot.
That's the best of your recollection?
Yes,
There
sir.
are other people in the room?
Yes, sir.
Okay. What did you talk about if you didn't talk about what had just happened outside?
What I asked her was, where was her husband coming from and where was he going to? I wanted to know where he was basically coming from and planning where was he going to go from there, from the stop there.
You were the first officer to have a conversation with her, is that correct? To the best of your knowledge?
I don't know if the others did when they were talking to her, met her outside.
Did she ask you what happened to her husband?
Objection, leading.
Well, I'm going to hold that objection. You can answer that question if you can.
I believe she was asking what happened. I think she was just in that emotional mode of what happened.
But you don't recall your response to her question?
I don't.
What happened?
No, sir.
Okay. Did you give Mrs. Sneiderman and the family any directions about what next to do after you talked with her?
What next from
Where
there?
they should go?
Well, she was inside with the staff. My plan was to go find an officer to take her to the hospital. She didn't need to be there.
Did you, to the best of your recollection, though, tell Mrs. Sneiderman and the family where they should go after leaving Dunwoody Prep?
I had made arrangements with the director of security at Atlanta Medical Center. I know him. And I had called, well, we had spoke early, and I called him back and told him that the family was going to be coming down there if he would just look out for them. I had arranged for the family, to, if they should show up at the emergency room, just to let them park over there.
Did you tell the family they should go home?
No, sir.
You don't, or do you remember?
No, because I had made plans to see if Ian can stay at the school.
Okay. After they left the facility, what did you do next?
Worked the crime scene. We had to get a search warrant. The car was impounded over to the crime lab, and I went down to the crime lab after the car was towed down there and stayed with the car because we had to process it there.
And when you say crime lab, you talking
The GBI crime
on
lab.
Pancrasville Road?
Yes, sir.
South of Decatur?
Yes, sir.
Did you go to the Sneiderman residence, and when I mean Sneiderman, Rusty and Andrea Sneiderman's house in Dunwoody that evening?
I do not recall going there that evening. believe it was the next day on the 19th.
Okay. Do you recall going with Detective Thompson that evening to the Sneiderman restaurant?
On the 19th?
18th.
I do not recall. I was at the crime lab for a period of time. That night, I believe we had gone to where Rusty had his present business in Buckhead.
And you're the sergeant in charge of the investigation?
Yes, sir.
Let me ask you some questions about general investigations. Police officers, detectives prepare a case file for the district attorney's office, is that?
Yes, sir.
What is included in that case file?
Everything pretty much that we've done during the course of the investigation leading up to an arrest.
And would that include search warrants?
Yes, sir.
And if there was a search warrant that had been issued on November the 18th, 2010, would that have included in the case file?
Yes, sir.
You have applied for search warrants before the DeKalb County Magistrate, right?
Yes, sir.
And this is a felony case, so it would have to go to the DeKalb County Magistrates.
Yes.
Correct?
Mhm.
You cannot go to the City of Dunwoody Court for a
No.
search warrant in a case of this nature, right?
No, it would have to go to the cab magistrate at least.
How many search warrants in the course of your 35 years have you gone to magistrate? Just give us a guess.
Hundreds.
And were copies made at the magistrate court of the search warrant before handing it back to the officer?
Yes.
So if there's a search warrant on November the 18th, there should be a copy of it somewhere, right?
Yes, sir.
Okay. And you don't have any recollection of not issuing a search warrant on the Sneiderman house on the 18th?
I personally did not apply for, well, excuse me, on the 18th I applied for a warrant. I sent Detective Maldonado down to the court to get a search warrant for the car. We have to have a search warrant to search the car at the crime lab. So on the 18th we did get a search warrant, but it was for
The car,
the car.
not for the Sneiderman residence, is that correct?
I do not recall a search warrant for the 18th for the house.
You went back on the 19th,
I believe that's when we made our first contact, yes.
and you did have a search warrant at that time.
I believe Detective Thompson had applied for a search warrant.
On the 19th, who were the two investigators from Dunwoody Police Department talking with Mrs. Sneiderman and her family?
Detective Thompson was the lead on it, and I was there.
Okay. And if you would, what was that recorded?
Yes, he had a digital recorder on him.
And prior to last night, have you had a chance to listen to that recording?
Not entirely.
Are you able to identify your voice on that recording?
I believe I will.
This time, I want to pay a specific part of, I believe this State Exhibit 61.
You may.
Yeah. You all right with continuing?
Yeah.
You want to continue?
How much more?
It depends on her. I think she's doing pretty great. I mean, she's doing good.
Whose voice was that who said, do you want to continue?
Yeah, that's me.
You're not from South Georgia.
No, I'm not.
To be honest with you, as long as she's strong for it, I'll stay.
Okay, go ahead.
Let's go.
Let's go.
Keep asking. Do you know anybody that drives a silver minivan? Whether it's a nanny at somebody else's house or...
No, I mean, you have a silver, I mean, this is family members, right?
Try anybody, just anybody. Yeah.
Yeah, he has a silver Odyssey. Who?
Yeah.
Who cares? Yeah, can you just stop fighting, please? But no, I don't know anyone else that owns a silver minivan.
Has there been anybody
Are these people here?
recently, when I say recently, within the past year, that has expressed an interest in you and trying to break up the family?
Yes.
Who?
My boss.
Your boss?
Yes.
What's his name?
Hemi. No, you have to tell me.
Hemi? How do you spell that?
H-E-M-Y,
Do you know what his last name is? What is it?
Newman, N-E-U-M-A-N.
N-E-U-M-A-N. How old is he?
46, I have no idea, in his late 40s.
What does he look like?
Short-ish, Todd's height.
How tall are you?
5'4". Somebody in town?
What else does he wear?
I have no idea.
Is he fat? Is he thin? No. Is he healthy looking?
Todd size.
How old is he?
150.
I'm thinking he's just crossing.
The voice that said someone in town, did you hear that voice, that question?
No, sir.
You were present during the course of the interview.
Yes.
After the interview, were you still in charge of the investigation?
Yes, sir.
Okay. And again, your Detective Thompson is the lead detective, you're the lead sergeant, and then we've got Sides and then Drogan, right? That's the chain of command.
Barnes is after, Lieutenant Barnes is after me, and then Deputy Chief Sides.
Now, at some point, the Dunwoody Police Department was able to connect a silver Kia to the main community.
Yes, sir.
Do you recall about when that was during the course of your investigation?
Well, I called him, I think it was December 26th.
Right. But my question was, do you recall when you tied the name to the car? Or that he became, after Ms. Sneiderman provided the main community, do you know of your personal knowledge when your department was able to tie that car to that name?
It might have been, we got the information back from the rental maybe the first week of December, I'm thinking. But we were keeping a log of cars. We were getting this community input from vehicles being spotted. So we were keeping a tray, I guess, of vehicles that were being reported to us as possible vehicles. So that van could have been placed at that time.
Can I approach the witness, Judge?
You may, what number is this, Mr. Morton?
I believe it's 31, Judge.
All right, D31, yes, sir, you may approach.
D32. Oh, so chocolate. Do you recognize that document, if not that particular document, that type of document?
This is a driver's...
Objection, Your Honor, to stating what it is. I don't know if he's going to try to introduce it. My understanding is that he's going to try to refresh recollection, and he's not doing that.
I'm going to sustain that objection. You want to rephrase that question?
I just asked, does he recognize the document?
Well, where you said, does he recognize, or do you, I thought the question was, does he recognize that type of document? Well, that's what I heard was the last question. Do you recognize, that document? You recognize that document?
I recognize it, yes, sir.
All right, go ahead.
And does that refresh your memory as to when Dunwoody Police first started targeting Hemi Newman?
Well, according to this, it was...
Now, listen to this question. He asked you, did it refresh your recollection? So, answer Mr. Morgan's question.
I did not personally pull this information.
Do you know as to whether, not your own personal knowledge, as to when Mr. Newman became a suspect? From a person of interest to a suspect?
He was a suspect on January 4th.
Was he a suspect when you identified that he was driving a Kia?
I had suspicions,
Okay,
but
so maybe we're dealing with semantics.
yes.
All right. Then let's go in the scheme of things. When was the first time you contacted Mr. Newman?
I believe it was December 26th,
Do you remember contacting him before Christmas?
possibly with a voicemail.
And what, if anything, did you tell Mr. Newman at that time?
I told him that I was investigating a hit-and-run accident occurring in Dunwoody involving a silver van, and I had traced that van back to him, and that I had some questions I'd like to ask him in person.
And was that a true statement or just a way to get him to come into your office?
Just a way to get to talk to him.
And do you recall whether or not you actually communicated with him voice to voice on the 23rd?
I believe I left him a voicemail. I talked to him again. I believe it was after Christmas. I'm thinking it was December 26th when I called him. Associates, anyone that had anything to do with Rusty and Andrea. We were still continuing with the investigation.
Were you concentrating at all on Mr. Newman?
No, sir.
But you had linked him to a silver Kia that was linked at that time.
Yes, sir.
Then what happened after you talked with him around December 26th?
I believe January 3rd was a Monday. We continued the investigation. January 4th, I was up in the Alpharetta, Roswell area. I located a neighbor that used to live in the neighborhood. I went to talk to her. I received a cell phone call around 11:10, maybe 11:15, and it was Mr. Newman saying he was back in...
Your Honor, hearsay as to what Mr. Newman...
Don't go into what you
She's saying,
I
don't
understand.
answer that question.
Don't go into what somebody told you. Just let us know what you did during the course of your investigation on January 3rd.
Okay, January 3rd is a Monday.
Right.
Just general investigation into the event itself, the incident, the shooting of Rusty Sneiderman.
Did you concentrate at all on Mr. Newman? Did you do anything regarding him?
No, sir.
Okay. How about on January the 4th?
That's when I received a phone call from Mr. Newman saying he was...
Wait up, no.
Hearsay.
Stop right there. You said you received a phone call, stop.
Okay.
That's what he said. Sustain the objection. Next question.
After you received the phone call, what did you do?
From Mr. Newman.
Anybody else?
Okay. He called me, I spoke to him, told him I was still interested in the van, wanted to talk to him about that. He says he didn't...
Objection, hearsay.
I'm going to sustain that objection. When you start saying he said, he's going to stand up and object. I'm going to sustain it, so I'm going to stop. Next question.
Did you have a conversation with Mr. Newman?
I did,
Where did that conversation take place?
on the telephone.
Did you have a conversation with him at Dunwoody Police Headquarters?
Yes.
Okay. And who was present during that conversation?
Myself and Lieutenant Barnes.
Was he under arrest at that time?
No, sir.
Was that conversation reported?
Yes.
At some point during that conversation, did you place Mr. Newman under arrest?
Yes.
At the time you placed him under arrest, were you aware that Mrs. Sneiderman had given the name Henry Newman?
No, sir.
At the time,
At the time of arrest, no, sir, I was in the interview room.
do you recall telling Mr. Sneiderman that
Mr. Newman.
Mr. Newman, that Mrs. Sneiderman had been in the office earlier and that he was a prime suspect? Do you remember telling?
I did not know she was not in the office with me.
Do you remember telling Mr. Newman that?
That she was in the office?
And that she said Mr. Newman was a prime suspect? Do you remember telling Mr. Sneiderman that statement?
No.
Mr. Newman, I'm getting my Sneiderman's.
No. And you're confusing me with it also. So maybe if we saw it, you know.
Let's back up. On January 4th, do you recall telling Mr. Newman that Mrs. Sneiderman had said that he was the prime suspect?
Your Honor, I'm going to object at this juncture as to anything that he may have said on that date as being hearsay.
No, if I understand the question,
Yeah.
Mr. Morgan is asking the sergeant, did he relate certain information? I think that was the form of the question. If I heard the question correctly, I'm going to overrule the objection.
Yes, sir.
So you may answer that question if you can.
You're going to have to ask it again, because I'm...
Do you recall telling Mr. Newman Your Honor, this time, just for the record, I would ask for the admission of Defendants Exhibit 33 and 33A, which is previously marked disc provided by the prosecution to the defense as the statements of him and Newman taken by this detective.
Objection.
All right. What's the objection first?
Well, first of all, he hasn't established the appropriate foundation to introduce anything in the evidence. Second of all, if he does establish that foundation, my objection is going to be hearsay.
All right. We'll sustain it on the first. You want to go ahead and establish the foundation?
Your
of
Honor,
this
my
witness?
understanding there was a stipulation. May we approach?
Oh, yeah. Okay, if there's a stipulation, come on up, lawyers.
Jeff Hullinger along with Attorney Jay Strongwater, and we are hovering in toward the lunch break here. We have heard from the chief of the Dunwoody Daycare. We have also heard from the lead detective from Dunwoody as well. The defense with an opportunity to ask many questions here. That's kind of how we have spent this morning, aside from the arguments before the judge where the jury was not in the courtroom.
I'm sorry.
This has been a day. This has
Yep.
been a day of a lot of technicalities, a lot of establishing timelines again.
Yes.
Not unfamiliar territory from what we've experienced over the last week.
Well, Ms. Newman looks like it's a direct contradiction to what Rusty Sneiderman's father said. So they're going count by count, and they're going to present testimony or documentary evidence such as the video that the detective is showing. And they're just going to march through the indictment. And once again, the roadmap is looking at Tom Clegg's opening statement and checking off what he said they were going to prove. They did not prove it through cross-examination. They're going to call witnesses now to establish those points.
And it seems to be within the realm of possibility that Andrea Sneiderman might be on the witness stand?
Again, it was interesting. The judge, as he's required, told Ms. Sneiderman that only she has the decision to testify or not, and the defense team interrupted, saying that that decision would be deferred until all the witnesses had been called.
Jay, you talked about it a little earlier that there seemed to be a chance that she would indeed take the stand, and I think the other thing that you talked about is you thought the evidence would probably end this week, so it looks like this trial will not carry into next week at this time.
I don't think so. If Ms. Sneiderman takes the stand, there's a lot of video that they can play back and ask her to explain what she said when she said it. But even with doing that, you would think that the evidence would close by the end of the week. Now, timing-wise, the judge likes to give jury instructions contemporaneously with the closing argument. So you don't want to have closing argument on a Friday and then jury instructions Monday. So if they can't get everything done by Thursday, it may carry into next week.
With this sort of mountain of evidence that has been presented, is there a danger of losing the jury at this point? Julie Wolfe has been inside the courtroom and has had some interesting observations about female jurors maybe paying more attention on certain issues as opposed to male jurors. There seemed to be more sleeping last week than there has been this week so far. Small things like that, you know, it's sort of like the Rosetta Stone. You try to use that as a means to figure out language here and what it all means. We don't know what it means, but it makes for some interesting conjecture.
Correct, and we can go down to Cheshire Bridge and talk to Madam Bell about what she thinks about the body language. And if the evidence is bad, you're hoping the jury's sleeping. If you got something dramatic, you hope that they're on the edge of the seats.
Congratulations, Jay. We've had a lot of obscure references over the last 3 weeks, but Madam Bell even sets a new obsurity, one that we have not known before. All right, we also have a lot of questions we will get to, but back into the courtroom.
To have a sidebar at this point in time with the lawyers, but don't draw any emphasis from that one way or the other. Thank you for your patience and your understanding. Just based upon the time, I'm going to go ahead and give you we're going to leave about 7 minutes, a little bit earlier than we normally do. But let me give you these instructions, because actually you've been in the building since 9 o'clock, and actually so have I. But let me give you these instructions at this point in time. When you go on this break, do not discuss the case. I allow anyone to discuss the case with you. Once I release you for this break, my preference is for you to leave the floor, do not remain upon the floor, because I don't want you to interact with anyone you should not interact with or hear anything you should not hear. Do not read or look at any media coverage pertaining to this case. Do not go upon the internet and do any research about this case. Do not blog about this case while it is ongoing. Do not go to any location that may have been made reference to. All the evidence will come to you in the form of sworn testimony and or any physical evidence that's introduced during the course of the trial. You're more than welcome to bring something to snack and or eat with you during the afternoon session. Do not consume any alcoholic beverages at lunch. Deputy Garrett will turn back over to you your cell phones, iPhones, and iPads so you can check your messages, but do not type, do not send messages, receive messages pertaining to this case, or have any conversation whatsoever. As I may have mentioned to you earlier, if you do decide to have a meal here in downtown Decatur and you want to sit at a restaurant, which is wonderful, they have great restaurants here in Decatur, but do not allow anyone to sit next to you who's talking about this case. And if they are, you either A, can move away from them, or B, have them move away from you. The lawyers and the parties cannot talk and interact with you, so I don't ever want you to think they're being rude or discourteous. It's currently around 5 minutes to 12, so we're breaking 5 minutes earlier than we have been. I'm going to release you, and we're going to reconvene with testimony this afternoon at 1:30, all right? Just go ahead and follow the instructions of Deputy Garrett. Everyone else, the lawyers that is and the witness remain at this point in time. Just follow Deputy Garrett. Have a good lunch. Enjoy your lunch. I'll see you back at 1:30. 1:30. Have a wonderful meal. See you back at 1:30. 1:30. 1:30. Good seeing everyone. Just follow the instructions of Deputy Garrett. Feel free to walk aggressively toward the door. Wonderful. Good seeing all of y'all. All right, lawyers, you may be seated. All right, Kelly. We're back on the record. For the purpose of what you need to do at this point in time, is there anything else for the record right now, Mr. Moore? No. All right. That should be 33, Exhibit D, 33, and 33A. Those exhibits are in your possession. At this, I'm going to use the term recess. If there is not a stipulation, as may or may not have been discussed, I would like the lawyers to talk and confer. The witness, Sergeant Corlino, will be available to review whatever document that needs to be reviewed during this session. The intent lawyers, and I'm directing our lawyers, is to be in a position to go forward at 1:30. Any questions about logistics from the state?
No, sir.
From the defense?
No.
All right. Sergeant Corlino, we're going to be on break, but the lawyers need to talk with you about the exhibit. So before you take I'm going to use the term a break. And I don't know if some people don't eat at lunch. You don't have to. I don't make anyone eat. But if you can do what you need to do with the lawyers and just be in a position to go forward at 1:30, okay?
Yes, sir.
Mr. Deputy, we're in recess till 1:30.
All right. We are in the middle of the lunch recess. I'm Jeff Hellinger with Attorney Jay Strongwater again. So the morning session has come to a completion on this Tuesday as we proceed forward. Why don't we take some questions here? We have been getting quite a few. Let me get my phone to play ball with us here. This is from Kristen. Even though Hemi Newman has already been found guilty, even though he has been declared mentally